It's been nearly half a year since the 2024 election, and now one race is still undecided, the race for the North Carolina Supreme Court. And that race enters its next stages of challenges right now. On Friday, a state appeals court ruled in favor of Judge Jefferson Griffin's challenge to be able to toss out more than 65,000 votes. So here to explain what's going on with all this ongoing case, the voters now stuck in between this legal challenge right now. Our chief legal analyst, Clive Rhodes, joining us here. So, Khalif, just so people can understand, because there's been a lot of back and forth with this since the election, kind of bring us up to speed.
We're up to speed. 734 votes separate this election.
Right.
We're talking about an election that had a machine count. It had a hand partial recount. It went to state and federal court. You're talking about the Court of Appeals on the federal level, U.S. District Court. They all kicked it back to the state court after the Supreme Court said it needed to go to the federal court. Well, now it went back to the state court. State court judge says, you know what, Superior Court, this decision, what you're asking us to do, we can't do it. The election needs to stand as it is. Well, they appealed that to the Court of Appeals, North Carolina Court of Appeals, and that 3-panel court decision came out last week, and you have 2 judges that said, look, this needs to be done. These 65,000 votes, they've presented enough evidence where this can be challenged, and they've set out the guidelines on how it can move forward. You had 2 going in that decision. 1 was dissenting. And so hopefully everyone is up to speed, but this is definitely a legal limbo position that I've never seen before. And so things are moving at a really, really fast pace, and that typically doesn't happen.
Yeah, I thought it was just me, because I was just like, what now? All right, so let's talk about these 65,000 votes that could potentially now change at this point. So what are the legal challenges that are still there?
Well, you got a couple challenges. First of all, her team, Riggs, has said the second this decision came out that they would appeal, that this decision was misguided, that didn't have any factual basis behind it. And so the very first step would be an appeal. But before an appeal is granted, before an appeal is even decided, this has to go forward. So until a judge's order is overturned, either by an additional judge looking at it or some type of higher level appellate judge, that order is still in effect. So the order is requiring and mandating that in those individual counties, that is all the counties across the state, the Board of Elections send out information to get the 65,000 voters to send in documentation to prove that they were a lawful voter at the time. It specifically said the applicable documentation that would be able to require that. And then during that process, they'd have 15 days, they as in the voters, to be able to submit that documentation or their vote will not count. So in between that time frame, while these individual counties can determine how that process will look like, where the funding will come to make that happen, what team will be overseeing this, Riggs' team will submit an appeal which would stop, pause anything that happened on that lower court's decision. But until an appeal has been granted and it's being heard in front of the Supreme Court, there will be no stay. And so the judge's order, or I should say the Court of Appeals order from that most recent decision is still in effect.
All right, so if Riggs' appeal now is denied, then in terms of this sets a dangerous precedent, doesn't it, for the races up and down the ballot?
Well, even if it is denied, I mean, right now, as it stands, if it's granted or denied, this is already a slippery slope. We're already going down a dangerous precedent for cases that can come before this, because you're talking about a number of things. These individual 65,000 voters that voted, they're not just talking about the folks that voted in the election for this race. This was a race that had other seats. And so if you're telling me that those 65,000 votes will not count, they're not going to count in any of the other races.
That's what my
it's not
concern was,
solely specifically addressing this race right here. And that's what the dissent said. Judge Hampton, who I've met a number of times in the past, know personally, he said that this is going to open up the Pandora's box, basically. If you're telling folks that now we can change the rules after the election has occurred, and because we can change these rules, now your votes may not count. On the other side, their team is saying, listen, this Court of Appeals decision says that if even one vote counts that should not have counted, it's going to be a dangerous precedent. So both sides, the majority opinion and the dissent, talk about a dangerous precedent being set and a slippery slope starting to occur. And so I'm watching this to see how the Supreme Court will now, or North Carolina Supreme Court will view this matter.
So in terms of the voters, I mean, what's your thoughts? How do people feel like, hey, my voice is heard?
Well, I think if you're one of those 65,000, it's going to be quick, right? This is an opportunity for you to say, hey, I had an opportunity, I had a lawful right to vote. Maybe I didn't have identification at the time when I registered, because the loophole, the situation that happened is it wasn't on the documentation that was required, and it wasn't required at the time. Now, what these individuals have to do is either present a valid identification, driver's license, some type of photo ID, or go to the Board of Elections and get them to give you the same type of ID you could have got before the election. The folks that I think are going to be in that murky area are the folks where Griffin's team alleged they've never lived in our state. These are folks that were in the military, were serving, submitted their documentation, and now they're saying those folks are who they're challenging. I think those are the people that are going to be hurt the most, because in that 15-day time frame, if you send documentation to them, they may never even receive it anyway because they're not even here. Right. So I think that's going to be problematic. But I will say the last thing Hampton said, and I can agree with this portion. The Griffin's team did not identify one single individual voter. They just talked about a block of voters, and that also is a dangerous precedent. Typically, when you bring a claim like this, you have to have an injury in fact. Normally, the injury in fact will be I'm listing the individual voters that I think either committed some fraud or voted improperly. They didn't do that. They just said all 65,000, and here you go. That's going to be something that the North Carolina Supreme Court will have to address.
Colleague Rhodes, we appreciate your insight as always. Thank you.